Hello friends, in the series on the income tax cases, today we will discuss the case of VIPUL AGGARWAL versus income tax officer. This case has been reported in 450 ITR at page number 254. The matter has been decided by Delhi High Court and the date of the judgment is 19th July 2020. 19th July 2022. In this case, a prosecution was launched against the company for not filing the return on time which was given by the department in the notice sent to the assessee. The assessee was a company. The return was not filed within the time limits given in section 139 subsection 1, that is 30th September. Thereafter the notice was sent to the company that you have to file your return up to 2nd August 2013. But the company filed the return on 12th August 2013. The return was 10 days delayed. But if we see, this return was very much delayed from the 30th September 2012. There is a very important judgment of the Supreme Court on this matter. The name of the case is Prakash Nath Khanna versus CIT, that is related to 2004 year, and that matter is reported in 266 ITR at page number 1. In that case, the Supreme Court held that if the assessee has not filed the return into the time prescribed under section 139 subsection 1 and have filed the belated return under section 139 subsection 4, even then in that case also the department has a right to launch the prosecution against the assessee under section 276CC. So we have to be very cautious in filing the return on time. If you have not filed the return on time, then do not take it very casually that you can file it up to 31st December, up to the extended period. Because once you missed the bus of the due date which is mentioned under section 139 subsection 1, you can be prosecuted even for not filing the return on time. Even if you have filed the return later, even then the prosecution can be launched against you. But in this case, the matter was that the prosecution was launched against the company. In the approval letter, it was written that the prosecution against the company is being launched. But when the trial was going on, the notice was also sent to the director of the company, and against the director also the prosecution was launched. Now the director of the company was before the Delhi High Court, and his plea was that I has not been adjudicated as principal officer under section 2 clause 35 clause B by the department. But the department was saying that since you have signed the return of income as a director, so there is a presumption under section 278B that you are the principal officer of the company, although it is a rebuttable presumption, but that is also in the trial. So as far as this ground of the assessee was concerned, that the prosecution cannot be launched against me because the department has not adjudicated me as a principal officer as mentioned in section 2 clause 35 clause B. So on this ground, the Delhi High Court was not with the director VIPUL AGGARWAL. But as far as the second point was concerned, it was the contention of the director that in the approval letter only it is given that the company is to be prosecuted, not the director. So until and unless there is a specific name of the director into the approval letter, the director cannot be prosecuted. The court said that the language of the approval letter cannot be so stretched to include the name of the director of the company for the prosecution. So in this case, the prosecution which was launched by the department was not according to the provisions of the prosecution. So the prosecution was deleted by the Delhi High Court. But the clear message from this case is that the written filing should not be taken casually. even for not filing the return on time, which is in section 139 subsection 1, the prosecution can be lodged against you. At the end of this video, once again I am repeating the name of the case. The name of the case is VIPUL AGGARWAL versus Income Tax Officer, and this case has been reported in 450 ITR at page number 254. The date of the judgment is 19th July 2022. Thank you, friends.